Attorney Gloria Allred, and welcome to Know Your Rights. This week's episode will focus on celebrities and other powerful individuals and how they can and have used their power against unsuspecting victims and what you can do if you become a victim of a celebrity. I'm joined today by my law partners, Michael Maroko and Nathan Goldberg. Hi, Michael.
Gloria.
Hi, Nathan.
Hi, Gloria.
And let's start with the first question involving sexual harassment in a celebrity's home. Nathan, will you give us some examples, please, of how celebrities have sexually harassed those who work for them in their homes?
Well, some examples would be a celebrity who thinks it's okay to walk around naked in front of people that work in the house, or demanding some type of sexual interaction with a nanny or a housekeeper, or it could also involve just groping someone who's giving them a massage. It could be a lot of different things that amount to sexual harassment, which is against the law, whether they're a celebrity or not. I just want to add that the celebrities are subject to the same laws, and even if they think they're not, they are.
Well, what do you suggest to victims who are too afraid to seek help from a lawyer if they've been victimized by a celebrity?
Well, first of all, many people are afraid to even call a lawyer because they don't know what the impact of that will be. And actually, by calling a lawyer, they are protected because lawyers are bound to keep their confidences and will not do anything unless the individual consents. So they run no risk by calling a lawyer, and they will find out their rights. I would urge people, if they think they've been abused or sexually harassed, to call a lawyer because it's completely confidential.
So you're saying that it's a completely confidential telephone call when they speak to the lawyer or send an email. And I know that you also won a $58 million verdict last year on behalf of one of our clients, a victim of sexual harassment. It was the largest verdict for sexual harassment of a victim in California last year. That, of course, is public, but you're saying confidential settlements prior to a lawsuit being filed, those are all confidential, and the victim's name will never be disclosed. Is that correct?
That's right. Nothing will happen unless the victim knows about it, has agreed to it, and often they don't realize they have more power than they think, because even though they think that they are weak and they don't have any power in the relationship, when they hire a law firm, it equals the playing field. They do have power, and they can assert their rights and seek justice, no matter how powerful the celebrity may appear to be.
Yeah, Michael, Nathan just mentioned justice for the victims of a celebrity. Would you like to add to that, how they can achieve that, perhaps through a financial settlement?
Yes, if a victim has been sexually harassed or sexually assaulted by a celebrity or by any influential, high-powered person, contacting an experienced employment lawyer does even the playing field. Once an employment lawyer or experienced lawyer surfaces, usually with a demand letter, in these days, especially after the Me Too movement, the playing field is such that normally there'll be a response from the attorney for the celebrity, and very often a confidential early resolution is reached. And we have seen our clients and victims of sexual assault and sexual harassment empowered by the fact that they did stand up, they did fight back, they did go to a good lawyer, and that there was a quick confidential resolution that provided for monetary compensation for the pain, suffering, emotional distress they experienced while working for that celebrity.
Nathan, would you like to add to that? Do you also agree that many victims are not as afraid now as they were prior to the Me Too movement?
Yeah, Michael mentioned the Me Too movement, and what we've seen is that victims are more willing to stand up, more willing to come forward, more willing to assert their rights than previously. And we were involved in numerous cases involving, Harvey Weinstein and other very powerful celebrities. And people are willing to come forward now and say, I was victimized. Something needs to be done.
Again, and they can come forward confidentially to an attorney. That will never be disclosed by the attorney without the permission of the client. Is that correct?
100%. And that's usually the first thing we do when people call our office. We assure them that they can communicate with us, even if we don't represent them yet, to tell us what happened, and it's completely, absolutely confidential.
And free. And we have handled a number of cases in which a celebrity or another powerful person gave a sexually transmitted disease, often called an STD, to a partner without first disclosing that they had an STD, even when the celebrity or powerful person knew that they had it. Michael, when is the celebrity liable for damages for transmitting a sexually transmitted disease to a victim?
Well, Gloria, the celebrity and any person actually in California and many other states is liable when he knew or she knew or should have known that they had the disease and failed to disclose that fact to their partner.
Well, how can a victim prove that that person who gave them the sexually transmitted disease knew that they had it or should have known?
Well, the proof they can prove it by either the celebrity having been told by a prior partner that he or she may have it and failed to disclose that to the current partner. The celebrity very often has been seeing a doctor and taking medication for that disease and failed to disclose that. There may be evidence on the celebrity's body indicating that he or she may have a disease. All those factors can be used to establish that the celebrity knew or should have known. And what we found is that that victims of who have been victimized by failure to disclose the STD, it has a devastating effect on the victims, on the partners who get it.
Yeah, they have. And I know you've handled a number of cases involving STDs for victims. What kind of damages, in other words, what can they show to prove that they were harmed and that they should receive damages or compensation for the harm inflicted on them by the STD and by their partners having inflicted on them?
Well, Gloria, there are various elements of damages, including damages for the physical pain. A lot of these STDs result in severe physical pain. And they can get compensated for that. In addition, they can get compensated for the resulting emotional distress arising out of that physical pain. Sometimes that emotional distress lasts their entire lives. They can be 20, 25 years old and experience pain emotionally for the rest of their lives, including in many states, once a victim finds out that he or she has a disease, they're required to tell future partners that they have the disease. And that could be devastating on their personal life. They can get compensated for all that. In addition, last element is all their medical bills while they're treating and for the rest of their lives, if they need to, are also compensable.
Michael, how else have we seen celebrities harm victims?
Well, Gloria, a very frequent scenario, unfortunately, deals with children. Those are people who are usually under 18 in many states. And a common scenario that we've seen is young children who go to rock concerts, for example, are enamored by the band that they're going to see, and a band member then picks them out, invites them backstage. The child is excited to go back there. This is the best day of their lives. They want to meet the star, and that very frequently results in almost an immediate sexual encounter after that. And that's childhood sexual abuse. It's illegal, and that kind of a sexual contact very often leaves scars, emotional scars, on the child as they go into adulthood and sometimes for the rest of their lives. And
I can confirm that. Of course, I represent a number of victims of R. Kelly, the famous songwriter, singer. And the victims often have been devastated by what he did to them. And that raises an important question, Nathan, about consent. If someone's abuse took place, let's say 20 years ago when they were a child in California, can they still pursue a claim against the celebrity, or is it too late?
Well, that's really two questions. First, on the consent issue, there is no such thing as consent. A child cannot consent to having sex with an adult legally. So the consent defense is no defense at all. As far as the statute of limitations is concerned, California just passed a new law that allows victims to sue within 3 years of the law going into effect, which was in January of this year, regardless of how long ago the abuse occurred. So if someone it could have happened 30, 40, 50 years ago that they had suffered childhood sexual abuse, and they can still file a lawsuit in California. There's also a similar statute in New York, shorter time period, but same concept of allowing victims to sue now for things that may have happened many years ago.
So you're saying, Nathan, that even if, let's say, a teenager, a 15-year-old or a 16-year-old says yes to sexual contact with the celebrity or other powerful person, that yes is not recognized legally, and the victim still has rights. And so my question, Nathan, is also, should a victim consult with a lawyer even if that victim has never gone to the police and doesn't wish to go to the police to report a crime against them?
Yes, whether they went to the police or going to the police really doesn't make a difference. First of all, the criminal standards are not the civil standards. In civil cases, there's less proof required, and oftentimes and frequently, you have situations where prosecutors do not prosecute these cases, perhaps because they're too old. Doesn't make a difference. If someone was sexually abused as a child, they can sue whether they went.
So you're saying that justice is still possible. Well, and that they should still contact a lawyer. Well, thank you, Michael, and thank you, Nathan. This concludes our panel today. Please note that we made general statements of California law, and we're not providing legal advice for any one particular case on this video. The law may differ in other states, and we take cases all over the country, and we work with co-counsel licensed in other states. So to all of you who joined us today, thank you so much for watching. Feel free to share your thoughts in the comments section. Our prior episodes of Know Your Rights are available on our law firm's website, Allred, Maroko, and Goldberg. And meanwhile, if you have any specific questions about your own potential claim, our office is open, and we will continue to provide free confidential consultations to you. Take care, be safe, and remember to always know your rights.
Bye.
Bye-bye.